You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
All right. Remain seated and come to order. Welcome back, members of the jury, to another amazing edition of Freedom Friday as we break down another trial victory. On today's episode, we are going to be joined by one of the smartest public defenders that I know, and this tale is truly amazing because in a time where the world has and was placed on pause, those who were charged with crimes have had to put their proceedings on hold. Barely any litigation has been able to take place. But this attorney and our guest today still found a way to take it to the box. You see, oftentimes public defenders hear the notion of, quote unquote, I'm going to get a real lawyer. And that always baffles me and my colleagues because we are some of the most familiarized people with the courts, the laws, and the changes. And that really benefits us. Our weakest component is just obviously our caseload and can't necessarily interact with our clients as much as we want to. But as our skill set as it relates to the law and advocacy, it is top notch. And this lawyer and this freedom fighter demonstrated that at a time where so little justice was being administered. So we're so happy to have her. We're really excited to get into the interview. And so, Dom, please introduce yourself to the members of the jury.
Thanks, Lucas. I feel as stressed as I would if I was starting an actual trial doing this. So my name's Dom, and like a couple of your guests before, I am not just a defense attorney, but a public defender. And I'm here today to tell you about one of my greatest victories so far as a public defender.
Well, we're really excited to get into it. I do want to give everyone just a little bit of background. Obviously, in a lot of courthouses and jurisdictions throughout the country since March of 2020, the COVID-19 pandemic shut things down. And rightfully so. We understood that there was a global pandemic that was taking the lives of hundreds of thousands of people, and that there was a need to put the health and safety of everyone above certain other aspects of life. But over the months and times and just passing of the virus and progression of things, it seemed that people were making advances and finding alternatives and ways to continue all around us, except for in the courthouse. Extension after extension after extension continued to be granted that denied individuals the ability to go to the courthouse, to have their cases litigated, and ultimately exercise their right to go to trial, whether they were in custody or out of custody. And so, Dom, why don't you give us a little bit of background as to, how this fight started, what was the status of your client as it related to in or out of custody, and how were you able to navigate through such a rough starting point?
Yeah, so this case actually originated pre-COVID. It was assigned to me in December of 2019, having an offense date from December of 2019. And so when I first got the case, I wasn't aware that I was going to run into any of these challenges. The only thing I knew is that I had a client who, from the day I met him, was very adamant that he wanted to have a trial in the case and that there really wasn't any need for me to make any plan for him except to have a jury trial as fast as possible. And so I said, okay, that's our plan. And early on in the case, there was one point where I was in trial on another matter. And unfortunately, because of that, I had to ask the court to give me a little more time on this client's case. And he was very upset with me for it. And it turns out that was actually a lot worse than I thought it was going to be, because then after that continuance in January of 2020, the court got shut down and my client was in jail. He was facing very serious charges and he had a very serious record that made it where this case, he was facing life. And because he was facing life, I thought, well, now here's this pandemic. Everything you just talked about is going on. And I think, unfortunately, this client is probably going to have to ride this one out in a jail cell. I don't think he's going to be one of these people who got the benefit, if you can call it that, the benefit of being allowed to be out of custody during this time. And so that created a lot of issues for us at the beginning, because he was really disappointed that I'd asked for that continuance. And I was too, because now we were in this situation where I thought he probably was going to be in jail maybe for a long time. None of us knew in March of last year exactly how long that was going to be. It turned out to be an extraordinary amount of time. And I don't know, we talked a little bit before we recorded about what was going on with my client. I don't know if you want to talk about that now.
Yeah, no, I wanted to just unpack a little bit about what you said. One of the things that definitely grabbed my attention and what you were just talking about is how you were saying that this was a life top case. So I think we should start there. Maybe explain to the members of the jury what exactly your client was facing and how legally it was the maximum consequence was a potential life sentence.
Yeah, so for this client, and this was very early in my practice as a felony attorney when I received this case, and I got it and I looked at, the charging document, and the charging document showed that my client was charged with a robbery, which is a strike offense. And then he was also charged with felony domestic battery, which is not a strike. And so it also alleged all of his prior convictions. And it had on the complaint that I received that he had been previously convicted of 7 strikes. Which if anybody's familiar with the court system, or with baseball, that 7 is way too many strikes. 3 is usually the limit. And so I was in a situation where I definitely had to go to some colleagues with more experience than me and say, hey, I just want to make sure I'm reading this right. This complaint says that my client's been convicted of 7 strikes. That means he's now facing his 8th strike. What does that mean to you? And my very, very intelligent colleagues who've been doing this a lot longer than me said, you read it right. He's got 7 strike priors. This is his 8th. And based on the 3 strikes law in California, that means that he is eligible for a life sentence. His potential sentence was actually 35 to life.
Wow. And so when you first got assigned the case, as you indicated, your client was in custody, and that would remain the fact. And you had talked about another case that ultimately made you have to file that continuance. But on this case, while your client was in custody, is that when you conducted the prelim as well?
Yes. So while my client was in jail, I had to continue it because of a trial. It finished relatively quickly, and it resulted in probably about a 3-week delay in this case. But we were able to do the preliminary examination while the client was in custody. And I guess I should say at this point that when we did the preliminary examination, my client didn't think the victim was going to make it to court, that he felt like she had been making plans to leave town before this happened and that she had probably followed through on those plans. And so I was wondering the same, is she going to show up? And, I actually just had the benefit of listening to your episode that you released today about domestic violence cases, about another domestic violence case. And I thought, oh, this is so timely, because I had the exact same thought about my case, which is I kind of wanted her to be there. I didn't think that the story that she was telling was exactly what happened. And I really wanted her to be present. And I made, all the efforts I could to find her. I wrote her on Facebook. I texted her on the numbers I had, and I tried to get in touch with her, and I just couldn't. So we did that prelim with just an officer being present. And in California, the law says that that's fine for an officer to come in and do a prelim where they testify and talk about what they heard from the victim, which would typically be considered hearsay in a trial. But in a preliminary examination, they're allowed to do it. And so they did.
So they do the prelim without the victim. Was there any conversation or controversy as to how much effort the people may have put into trying to find the victim or to even get her there?
So I definitely had made some efforts before the prelim, which were mainly because I needed to know if I had to transcribe all of this body worn footage that I had. And I know that I communicated with the prosecutor at the beginning of the case. And because of what my client had told me about her planning to move out of state, and just said, hey, do you know if that's true? Do you know where she is? And I'm not sure if they directly told me when we did this prelim before the pandemic, whether or not they could find her, but it was definitely implied that they didn't think she was going to be a very easy witness for them to find.
Okay. So they do the prelim without the victim. I'm assuming that client is bound over on both counts, and that new dates are then set. And then that is where we come back to the point of the story where his newly set dates conflicted with a trial that you were already in, right?
Exactly.
Okay, and so then that takes us into the COVID period. And at that time, is it my understanding that your client, he was still in custody, correct?
Yes, my client was in jail, and I was doing with him the same thing that I was doing with nearly everybody I represented in late March and early April of last year, which is that I was meeting with them regularly because they were in jail and they had a lack of access to information, and they really didn't know what was going on with court or with the world. And I was basically telling them, hey, I just want to let you know that I haven't forgotten about you. I'm thinking about you. I'm worried about you, but it relates to my representation of you, I have absolutely no idea what's going on. I just don't know. And I think most of us had the same experience, which is that we were just telling our clients like very unconfidently, I don't know what's going to happen next. And some of them understood, and some of them, like my client in this case, said, I don't accept that. I don't think that that's the way this should work. It's my constitutional right to have a trial, and you're taking that away from me, and I don't think that's fair.
Yeah, he's totally right, and you're totally right. I mean, there was totally a period where for months we just would not know what was going on and wouldn't even get potential answers. When we first got sent home, I think everybody was given the notion of like, we'll be back in like 2 weeks. And then when that 2 weeks came and went, from that very moment, it was, we'll let you know more when we get it. And it almost went from really like a day-to-day progress report to find out what was happening, almost for about, 6 months. And so when there was a certain period of time, though, where we were able to start getting some virtual court hearings going and being able to get some things addressed, did there come a point in time where, things got so critical and you had the ability to address the status of your custody where, that opportunity arose?
Yeah. So for a lot of my clients, that time came quickly because the court changed a lot of their rules, changed a lot of the reasons that they would or wouldn't leave someone in custody. And a lot of my clients, I would say the majority of them, were placed on lists marked as special people who weren't dangerous enough to remain in custody given the pandemic and let go. This client, because of his current charges and his criminal history, was not one of those people. So I went to meet with him and said, hey, a lot of people have gotten lucky. They're leaving. You're not on these lists. And he said, well, I do have, I don't want to really go into like what his medical condition was, but he told me that he had a medical condition that I was sure was a reason that he should be let out of custody. And so I did a little personal research, and I was actually able to find a doctor who worked for the Boston Medical Center, which was just kind of luck that I was able to find this person who worked on the opposite coast, specialized in the condition my client had. And I didn't know anything about her. I found her email online, and I fired off an email that said, hey, my client has this disorder that you specialize in. He's currently in jail. He's facing some pretty serious charges, and I'm trying to get him out of jail. Will you help me? And I was really, really fortunate, so was my client, that this person didn't care that I'll call him Mr. T, didn't care that he was charged with something serious, didn't really care anything except that she was hearing that a client who had a condition that she specialized in had not been convicted of anything, was pre-trial, and was being held in custody during a worldwide pandemic, when very basic things that people were being asked to do in March and April of last year were literally impossible in the jail. You can't social distance in a jail setting. You can't avoid, close contacts. Things that we take for granted. In jail, people trade things like food and supplies all the time. It's part of the way that they barter and do business. And so to say even simple things like don't drink off each other's cup or share food, well, in the jail, that's something that you do as a bartering system. And so it just wasn't realistic. Now, I was also hearing from the people who I was talking to that were still in custody that they were being told that there weren't even cleaning supplies available anymore and that they should be wiping things down with wet rags. So I was concerned. The doctor was concerned, and she said, "I'm happy to help you. I'm not going to charge you or your office any money to do this." She reviewed his medical history. She confirmed that he had the disorder. And she wrote a letter directly to the court saying that it was her professional opinion. And it was a well-sourced letter. She did cite to authorities saying that the client should be released because of his condition. And lucky for us, the court agreed. They read that letter, and I think they were put in, frankly, probably a very uncomfortable position where they had to say, I have this letter from a professional, specializes in exactly what client has, and I think I have to let him out. And the judge did the right thing and sent my client home. Obviously there were conditions of his release. He wasn't supposed to talk to the victim. He could be searched without a warrant or probable cause. He was supposed to stay at home and stay out of trouble. But the court let him go, and it was fortunate in some ways that they did that because it secured his physical safety. It was unfortunate in others because it kind of put him in the back of the line for this trial that he'd been asking for so long.
That was exactly where I was thinking, how beneficial on one end, but detrimental on another. You're totally right that one of the biggest struggles I think that happened right away with the pandemic was how are you going to take care of the in custodies, because once it hits the jails, it was likely to run rampant, and then the potential of that spreading to the sheriffs or court staff or lawyers, and all of that became such a big hurdle. And so that's such a fascinating story that you were able to get into connection with a doctor who was willing to advocate for the most vulnerable, not only the most vulnerable, but the most vulnerable in the most vulnerable position, because being sanitary and sanitation is not really top priority in the jails. It's almost, that stuff is offered in the commissary. It's not necessarily given to all the prisoners or inmates, and so not even everyone has equal access to soap or hand sanitizer or just other basic needs. And so that's amazing that he was able to get out. But as we were talking about, because he was able to get out, he now has an out of custody status, which our jurisdiction had generated a priority list, which, targeted in custody felonies first, and then put anybody out of custody on the back. And so ultimately, how did getting him released out of custody affect his now newly set trial dates?
So because he was released from custody, this priority list that you talked about, one of the criteria that the court had been using all along for prioritizing who would or would not get a trial given the pandemic was that the person did have to be in custody in order for them to be given priority. And I guess we should note here that priority back then and even now doesn't mean that you get to go later. It means we let every custody person go before we even discuss the potential of doing an out of custody client's trial. So I think it's really important for people to know right now that we do have these priority lists, and it's only people who are in jail. And we are still some 15 months later telling our out of custody clients the same things that we were telling them a year ago, which is that we really don't know when they're going to become the court's quote priority. Because right now they're operating a single courtroom, at least in our courthouse, to do trials from. So no time soon. I'm advising people that they should expect it's still going to be another six months to a year before an out of custody case goes.
Yeah, I know that's definitely a battle that us and several other counties and jurisdictions are still facing as, we continue to, battle through COVID. But I know in our jurisdiction, a lot of us on the front lines, persevered, got the vaccination, did what we felt like it was necessary to do for the best interest of our clients to get back into the courthouse and to get things operational. And so hopefully that happens. But in the meantime, you were still able to demand justice for your client, ultimately exercise the speedy rights he had in the best way that you could. And so let's get to the next hearing. We know that we had the prelim and that he got released, and so now we're, I think, possibly late September of 2020. It was the next time that we had any kind of hearing on this case. And so why don't you bring our members of the jury up to speed as to that hearing?
Yeah, so after the preliminary examination, everything closed down. My client gets out of custody. I spend the summer and part of the fall telling him I don't really know when we're going to have court. And we finally got to this point where out of custody clients had hearings scheduled. Now, they weren't trials. They were just dates where we were going to meet with everyone and say kind of what we thought should happen next given the pandemic. In September of 2020, my client told me, you shouldn't do anything besides show up on that day and let the judge know that we're ready to start our trial. And I had been prepared for the trial. I honestly had been ready to go since the preliminary examination, just because of how much time I had to spend thinking about what would happen if the victim wasn't present. I was able to be ready. And so I told him, great, that's what we'll do. And in September, we appeared before the judge from out of custody in a virtual hearing. And I told the judge that we were ready to proceed, that my client was demanding, in fact, that he had a constitutional right to a speedy trial, and that we were ready to start. And the district attorney's office told the judge that they were also ready to proceed, and that they understood that because of the worldwide pandemic and the rulings that our specific court was kind of following at the time, that even though I said I was ready and they said they were ready, that the trial wasn't going to start on that date. And the court then pulled out a script that they used on hundreds, maybe even thousands of cases around that time that said, you know, given the worldwide pandemic, the lack of available courtrooms, and the extensions that have been granted to our office, this trial is continued. And that was it. And I had the same conversation that I'd been having with my client for quite some time, which is that I believed in his constitutional right to speedy trial. And I wanted to do this trial as soon as possible, because it was his position that what the court was doing was giving the prosecutor's office more time to build a stronger case against him, which is at least one of the reasons that you're supposed to have a speedy trial, is so that the government can't take as long as they want to kind of make the shoe fit. And so my client was upset and I was upset, and we had our trial set for February.
And a really big thing, it sounds like it happened right there, even though it was subtle, you know, because I think as most people experience that the first 6 months of COVID were probably the hardest. The most change had occurred, the need to adapt, the loss of jobs, the ability to pay bills. Like, so many people were displaced from where they previously were in the matter of 6 months. And, you know, that was true on our end for our clients. I'm sure that was true on the prosecution's end as it related to their victims. And so that's why there was a constant need of checking in on both sides to make sure that all, you know, necessary parties were available to then take on the case. And so, you know, one of the things that I wanted to highlight is that, like you were saying, absolutely, one of the things that the court had in place throughout the state was this extension of speedy trial rights. But in order for the parties essentially to get the benefit of those without having to enter into any kind of time waiver, was that they needed to still be ready. And because, for example, in this case, if the people weren't ready, then statutorily they only have 10 days to trail in order to get all of their evidence and all of their witnesses ready. But here in late 2020, both parties made the representation that they were ready to proceed to jury trial. Is that right?
Yeah, we all got together and told the judge, you know, hey, we're ready to go. Find us the courtroom and we'll do it. You know, in September at that point, I don't think that there had been a trial in our jurisdiction at all since the court shut down in March of 2020, and it was now September. And I think we were gunning to be the first, you know, just asking for a place to do it. We made a lot of suggestions about where we could, but none of them were accepted or found to be acceptable.
Okay, so good cause was ultimately found because modifications hadn't been made in order to allow for any kind of trials to officially start going. And so why don't you then take us into the next court date that came and what took place at that hearing?
So the next scheduled court appearance, you know, I said February before, but I think we actually had one of these hearings in January also, where it was kind of performative. We all showed up and said we were ready. And the court set the trial for February. And that's because we experienced something else during this time, which was that we were being promised every time that we showed up for these type of hearings that it was just going to be a couple more months before we were all going to be able to go back in some capacity. And so we would show up and this promise would be made and we'd all go, okay, this is it. We'd write our boss and say, the judge told me that this is it. We're really going to start a trial. And so it was always like hope springs eternal. We always thought it was true. And so we did one of these in January. The trial was set for February. And leading up to the trial in February, my client and I started having conversations about his rights and what we could do to kind of make this move along. And my client essentially told me, I don't think you're doing your job anymore because I know I have these constitutional rights. And the fact that you're telling me that there's nothing you can do, I don't think is true. I want you to do more. And that really lit a fire under me to start reaching out to people who I trust, people who've been doing this job a lot longer than me and say, hey, like, what do I do for this man? And I felt like everyone was telling me, you just can't do anything. There's nothing you can do. And interestingly, the one person who did provide me with something that I could do that might actually work was my client. He called me just one day before our scheduled hearing in February, late at night, to tell me that he'd been reading about it himself and he'd been thinking a lot about his options. And he had decided that it was in his best interest to let the court know that he did not want to have a jury trial. He wanted to have what's called a bench trial, which means that he gives up his constitutional right to have 12 jurors decide the case. And he leaves his fate really in the hands of just a judge who hears the evidence and does a trial just like every other one that the listeners have heard about. There's just no jury to do it with. And I thought that's very scary. This is a very serious case. I had a lot of faith in my ability to argue the case and to prove the points, but there's a fear that gets instilled in you when you're told that you don't have to convince 12 people. You have to convince a judge who, frankly, in most jurisdictions, probably used to be a prosecutor. And I was afraid. I told my client, I don't know if I agree with you. I agree with you as far as strategy is concerned, that this might be a way for us to get it done. But practically, I don't know if you're going to get the result you're hoping for putting this in the hands of just a judge. And he told me that he would think about it overnight and let me know in the morning.
That's such a ballsy move from a client who is facing a life top case that, if convicted, could potentially spend the rest of his life in prison. Because you're right, that changes so many different aspects and dynamics about a case and about the trial. You highlighted one, how it goes from, having a panel of 12 to make the considerations to one. But then it's also none of the 12, or most likely none of the 12, have any kind of legal training or experience, compared to now the sole person is like at the epitome of like legal knowledge and experience, and is in a position to even, create case law. And, all judges have that ability to also, the members of the jury who, even when they're instructed to not necessarily let their sympathy or their biases or just their, true selves play a role in the jury process, like, you now have a trained judge who is, as you said, definitely has prior legal experience in one way or the other, really kind of being able to set emotion aside and just focus on the law and the facts and the legal basis of things. And so generally, that's to a detriment to our client. And so hearing that, yeah, it totally, I could imagine being surprised. But at the same time, he's absolutely right in how everything that was going on in the world really specifically only addressed jury trials, and how there wasn't any kind of legal authority out there that stripped him of his right to do a bench trial.
Yeah. And so I, as soon as we had that conversation, I hung up the phone with him and started calling my coworkers that I knew would answer the phone at 8 p.m. to tell me what they thought, is this a good idea? And I got a resounding no. from everyone that I asked, this probably isn't your best bet. It's probably not going to go the way you want. But if that's what the client wants, then that's what you have to do. And so I started preparing overnight to kind of see if I could get all of my bearings on what that even meant, so that when I showed up the next morning, if my client told me that's what we wanted to do, that I was ready to do it. And I went to bed that night very worried. And I woke up the next morning. I was actually walking into Starbucks when my phone rang, and it was my client. And I thought, this is it. He's going to give me the answer. It's 7:50 in the morning. Court's at 8:30. I answered the phone. I said, hey, how's it going? He said, you know what? It's great. And I want a bench trial. And I said, okay, if that's what you want to do, then that's when I'm going to let the judge know. Just make sure you're logged into this video court hearing at 8:30 so we can tell the judge together that that's our plan. And I drove to work as fast as I could.
Sheesh. Okay. So at this point, we're over a year from the incident date. Client has never once entered into a time waiver at all times, has demanded his right to move forward on his speedy right trials. And the time has come again. Here he is before the court. He's out of custody and he's entering up for a jury trial call. But now he wants to waive his right to a jury trial and move forward with a bench trial. Walk us through what happened.
Yeah, so we logged in. The judge said, this case is here for trial call. I'm sure he was feeling the same way that the prosecutor was, and the way I would have been if my client hadn't given me this nugget 30 minutes before court, that this was just going to be both of us saying we were ready and the court continuing the case. And I said, no, Your Honor, he wants to do a bench trial. And the court says, oh, are you sure? And my client's there. He says, yeah, I'm sure. And the court says, well, I'm going to need to take a recess because I don't know what to do here. So the court takes a recess. They make a phone call to the presiding judge. And my client takes a recess. He calls me just to ask one more time if I think this is a good idea, which I've never told him it was. So we go back in front of the judge, and judge says, I talked to the presiding judge. He says he has a courtroom for us to do a bench trial, and I'm going to assign your case to that courtroom. And, I was nervous, but I thought, great, mission accomplished. We did it. We're going to finally have this case heard. My client's finally going to get to have his trial that he's been asking me for at that point, 14 months. And the prosecutor said, Your Honor, we would just like a few days to kind of coordinate everything. We weren't expecting this request, which is true because my client didn't tell me until the morning of court. And so they were surprised and they asked for a little bit of time. And the judge said, yeah, I'll give you time, but I just want to let you know now I'm assigning the trial to this department. You guys should all be there on Tuesday morning. And Tuesday morning happened to also be my birthday. So I thought, great, luck's on my side. And they told us be there Tuesday. And that was it. I prepped over the weekend. I got a call from my client saying that he was pretty sure that the police were out there trying to, do the rounds to see if they could find the listed victim in the case, because they had been knocking on doors, including his, to see if she was there. So I thought, well, the prosecutor must be ready to go too, because they're laying the groundwork to put on this trial. And we showed up on that Tuesday morning, and that's kind of when things went south.
Well, depending on, I guess, how you look at the situation. Yeah, so client has finally got his desire. He wanted to go to trial. He wanted to basically see if the people were going to be able to produce this victim so that, her credibility could be questioned, because from his point of view, that seemed to be the crux of the case. And without her and without that, there was none. And, between the two of you were able to find the legal, I guess, loophole, so to speak, and what allowed an out-of-custody person to exercise their speedy trial rights. And so that sounds just like some fantastic lawyering, and quite frankly, from a source that you, I think, maybe would have least expected it from. And so it's crazy how that works out that way. But, we're here. We've been assigned to a trial department. We're answering up for trial. Walk us through what happens now, essentially, on the first day of trial.
Yeah, so I guess I should say that at 3:30 p.m. the night before, some Monday night, I got an email from the prosecutor that said, "Hey, I just wanted to let you know, give you a little heads up. Um, we looked into it and we decided that we're not going to waive our right to a trial. And I guess now would be as good a time as any to note that pursuant to the California Constitution, it's not just a defendant that has a constitutional right to a trial by 12 people. The prosecution also has that same right. And so the only way that you can have a bench trial is if both of the parties agree, which in my opinion basically makes it a zero-sum game, because if either side thinks that their case is so good that a bench trial is the way to go, the other side is probably never going to say yes. So I was surprised by that. I wrote my colleagues and said, "Do you think he can do this?" And they said, "Oh yeah, it's part of the Constitution." And I thought, I guess I better hop on Lexis and do some legal research about this, find out what's going on. So I did. I spent my whole night researching, and I found some case law that I thought was pretty good for me on the issue. And so I showed up Tuesday morning, ready to cite it. I sat down. My client sat down. I should say at this point that when we waived jury, my client also, on the record, had waived his constitutional right to have the prosecutor present. So the prosecutor was planning to do this whole trial through video conference. And he'd also waived his right to have the witnesses present. So the only people who were there in the courtroom were me and my client and the judge. Everyone else was planning to appear virtually. And, I saw the presiding judge on my way into court, and he said, "Oh, Dom, are you ready for trial?" And I said, "I guess so. I don't know what's going to happen." And he said, "Oh, I thought everything was squared away." And I said, "Me too, but I'm not sure." And I went upstairs, and I guess he'd caught the judge who was doing the trial in the hallway somewhere, because she came in and sat down and said, "I heard there might be an issue. I thought we were about to start trial." And the prosecutor said, "Oh, yes, Your Honor, I think there is an issue. We've looked at the facts of the case, the potential exposure, and other information that we have, and decided that it's a trial that we want to do in front of a jury. So we're not waiving our right to a bench trial." And the judge said, "Dom, what do you think about that? Because the prosecutor is right. We do have this right to a trial. Both sides have it, and so you need to tell me if you have anything to say about that." And I thought, this is it. I found that case. It's really good for me. I said, "You know what, Your Honor, I do. I think I have authority that says that we should move forward today. And on top of that, I think that the prosecutor coming in now and making this argument is a little, it's not really the fairest thing to come in and say that they looked at the case and decided it needed a jury, because the case has been the same the whole time. And last week when we were all sitting in court, they didn't say a thing. And the judge looked at the case that I had found, which basically said, if someone asks for a bench trial and you don't object, then that's it. The only person that they have to be sure really, really means it is the defendant. And the court had taken so much time with my client to basically threaten him and tell him that this was a bad idea, that there was no way that it was going to be argued that he hadn't waived it. He did. And I told the court, my client took the time to find out if this is what he really wanted to do. And the court took the time, they stopped court to make this phone call to find out. The prosecutor didn't do anything except say they needed a couple days. And the case says, in my opinion, that means that they acquiesced and it's time to start trial. And the judge read the case and she agreed with me. She said, I think this is the first day of trial. I think that you gave up your right to have a jury trial when you didn't say anything last week. And that's kind of where things blew up.
Man, I was reading through this transcript, and I'll drop the Evans case in the show notes for anyone who's interested in checking that out. I know I did, but that was, you're right. Like, that was such a persuasive and almost, and I guess you'll be able to explain whether or not it was ultimately binding, but such an amazing move on your part to be able to find that case law that suggests it, because I think a lot of times, at least on our end, we're always warned about when in doubt, object, because if you don't object, you potentially are waiving multiple rights. And so even if you think it might be legally fine, even if it's just questionable, one of the things we're always taught is just to object so that you can preserve it for a later date. And that's exactly what this case said, that, the waiver of the client for the jury has to be, very, very explicit in detail, which you just said that's what happened. But as far as all the other parties, it didn't go into detail. And so kind of that rule of thumb that if you don't object, you waive it, takes place. And so I know in the transcript, the judge who was sitting on this trial found that case to be very, very persuasive in ultimately her ruling. And so why don't you tell us a little bit of what was some of the things said on the record that, try to now overcome this hurdle that it looks like the prosecution is facing now because trial has started and, you'll have this favorable case law.
Yeah, so I'll just reiterate what you said, which is that when I found this case, I was like, these facts are perfect. They're like the same as mine. So I was so excited to have it. And the judge made this ruling, which I expected that really any judge that they could have put me in front of would, because the case was just so clear. And when the judge made that finding, I kind of encouraged, I think, the court to inquire with the prosecutor. Are you ready? Now that I've made this decision that we're about to start this trial. Are you ready to go? Is the listed victim here? And the court, turns to the prosecutor and says, well, is she? And the prosecutor says, no, she's not here. We haven't been able to find her before COVID, and we haven't been able to find her since COVID, which I'm not great at math, but that equals we've never been able to find her. They don't know where she is, which I knew was true because I couldn't either. And I felt like I needed her to be there more than the prosecutor does. And so I had felt like I had probably made better efforts than they had to find her, and I couldn't do it. And I thought, if I can't, they probably can't. And the judge said, well, what are you going to do when she's not here? Because it sounds to me like she's the only person who can really help you prove any of this up. And the prosecutor said, well, we really need more time. It wasn't fair. I think it was claimed more than one time during these arguments that the fact that I had showed up that morning and said that I wanted the bench trial, that it was an unfair surprise by the defense, which it was one of those things. It was a surprise. But as all the listeners have heard, it was surprising for me too. I didn't hold back. I didn't wait to tell the prosecutor. Now, strategically, it may have been smart if I'd known it for a long time to not tell him. But I didn't have the benefit of strategy here. I was just as surprised as he was. And the court kind of leaned into him, I think, and just said, you've never been able to find her. It's time to fish or cut bait. I think that's a quote that she used a few times during the conversation that she had with all of us. Yes, there was a pandemic. Yes, there have been intervening circumstances. But we're all sitting here today after you showed up last week and said you were ready. And so unless you have something to say, I'm just not really sure why I shouldn't dismiss this case at this point. And, those are those words that make the prosecutor, in most cases, go from 0 to 100, which I think is exactly what happened here. The prosecutor said, no, based on these extension orders, I have a right to have this hearing later. I have a right to have it in April, which it was February at the time that we were making these arguments. So they were arguing to the judge basically that they had a right to have 45 more days to try to get this trial off the ground.
I want to interrupt you right there, though, too, because I think that was a really good point to highlight that there was, at this time, there are still the extensions going on, which, had given them extra days. And, when I was going through this transcript, I thought, I don't know how you felt emotionally, but I could only imagine the type of roller coaster that was going on in your brain, because ultimately, there are three different changes in the rulings that ultimately we're going to get into that all deal with like date-based kind of reasoning.
Yeah, so it was definitely for me, because I was there in person, I felt like I had an advantage that the prosecutor didn't have, because the court could see physically how I was being impacted by kind of everything that they were doing. And the prosecutor didn't have that benefit because they were just like a talking head, basically. And so the court, throughout the transcript, I think you can see leans towards me, then leans towards the prosecutor. And it was really hard for me to stay calm, because I also could tell because you get that little alert in a video conference when people are watching, that as this hearing was kind of blowing up, more and more people who are way more important than me at this job, started logging into the hearing. People who I admire, people who I want to tell my boss that I did a great job. And I could just see all of that happening. And I was just thinking, this better go my way, because there's people in here watching now that they're going to remember if it doesn't. And so it was stressful. I think you can actually see right at the beginning of the transcript, the court tells everybody to sit down. And I actually told the judge, I can't sit down right now. I have to keep standing, because I was just so nervous.
And I think I agree with you. I think being there, it sounded, I could imagine how that was an additional level of persuasion and just obviously shows the eagerness of, one, your client who was continuously demanding this speedy trial, and two, being ready and available to fulfill that client's desire and need. And so I know that they were pushing to that, ultimately they were trying to kind of backpedal it to the jury trial and reset it for a later date in a couple of months. But that ultimately was denied by the judge. And then they kind of refocused back to at least their statutory right to trail for a few days. Why don't you walk us through how that kind of argument went?
Yeah, so the court tells the prosecutor, I am not going to continue this as long as you're asking me to. You do have a statutory right, which we talked about earlier, which is to trail through 10 days. And so I'll give you the rest of those 10 days. And I think the prosecutor thought that meant that they had 10 days, but I had already done all this math and we had passed through most of them. It was, I think, Tuesday at this point. And I said, Your Honor, if you're going to go with that, then I think the latest that this can be set for is Friday of this week, which is just 4 or 5 days later. And the judge said, okay, that's what I'm going to do. I'm going to give you until the 10th day to see if you can piece this together. I've already found that you'll be doing this trial with no jury. And so piece it together by Friday, or that's it. And the prosecutor made what, in my opinion, was a very big mistake, which is that they responded to that by saying that they didn't think that they were going to be able to subpoena the police officers who investigated this case before Friday. And I think that got judges, spidey senses going, that meant that the prosecutor had shown up with no witnesses ready to start the trial. And she asked him very directly. She said, wait a minute, you don't even have police officers here? And he started trying to explain why he didn't have any police officers. He said, we have to give them 5 days of notice, 5 business days of notice. And it hasn't even been 5 days since we showed up and we asked for this bench trial. Which I'll just say now for the benefit of everyone is true. If you want to subpoena a law enforcement officer by just faxing them the subpoena, you do have to give them 5 business days of notice. But you can also subpoena a law enforcement officer the same way you do anyone else, which is that I could give you a subpoena 30 minutes before court and you would have to show up on it. So the court heard that and they just said, I can't believe that you're here and you don't even have your police officer witnesses ready to go. And that was really where she kind of shook things up. She had heard enough.
Well, yeah, I was going to say, I think at one point in the transcript, there's a quote from the judge that talks about how, she says that I've been bending backwards for you. I was very close to actually resetting this date to April, given the extensions, but, was persuaded not to because and found that this is going to be a bench trial, which isn't covered by the extensions, to then, okay, well, maybe if we don't start today, I'll still give you the extra days to be able to do things she was not happy that, when she was like, again, I'm going to even give you even extra days, that they didn't think that they would ultimately be able to be ready, and that they technically showed up to a trial day one of trial without being ready to go.
Yeah, and I think that was where she really put her foot down. And I mean, the transcript is a little different than what I remember in my head. So I'll just tell you what I remember in my head, and then if you want to fill in any gaps, you can. But I just remember that she was holding the court file open. She'd been looking at it a lot as we went through. And as soon as she realized that the police officers weren't there, she slammed the file closed. She said, "That's it, dismissed." And to my recollection, she actually said, "Dismiss, dismiss, dismiss." She said it several times in a row.
That's right. That's right.
And then she held her fingers out and she listed out the reasons that she was dismissing the case, which was speedy trial violation, lack of prosecution, unavailability of witnesses. And then I think she kind of trailed off as she was thinking of maybe more reasons that she was going to do it. And all I was thinking while she was making this list is, this is great. There's no way the prosecutor's ever going to be able to appeal this, because she just listed so many legal reasons that she was absolutely done with this case. And she, turned to my client and said, doesn't mean that this is over for you. Like, things could still happen with this case. And I just sat there kind of quietly and thought, I don't know if that's true. I don't know if anything else can happen. The way that she made that finding was she just listed so many reasons that she was dismissing it. I thought at least one of these is probably it for this case.
Well, I had the pleasure of being in the virtual gallery that day, and think it's fair to say that I think everybody was so surprised when she ultimately said those magical words of dismiss, but absolutely knew how deserving it was, just based on the legal arguments that we heard. And I think one of her final basis was ultimately just in the interest of justice, because like we've talked about this whole time, client never entered into a time waiver. He always wanted to exercise his constitutional right to do a speedy trial. And you were able to navigate through some of the most unprecedented times, one of the world pandemics that, there's only been a couple of, to be able to get one of the most just and fair verdicts or results in a case. And so that's just absolutely amazing story. That level of lawyering, I think, should be highlighted and known, because, we're able to do that every single day, and we do. That's why we do what we do. And so thank you so much for sharing that story. This episode in its whole self has been a great example as to why we fight and we fight and we fight and we take matters to the box. But for our members of the jury, why don't you go ahead and close us off with, what is the importance of taking it to the box mean to you?
Thanks, Lucas. So I've thought about this a little bit, and I think that the best thing that I can say now is that I come from what I would call a long line of public servants. My dad was in the military. Most of my family is law enforcement officers, and the members of my family who aren't law enforcement officers are educators. So pretty much everyone I've ever been surrounded with in my life has been a public servant of some kind. And I think that I found a way to perfectly kind of weave together the two backgrounds I've described, right? The law enforcement aspect and the education aspect, to do this job where I get to meet members of the jury all the time. I get to learn about their backgrounds and experiences. And that's why ticking it to the box is so important. It's because once you know that about those people and you know their backgrounds and their experiences, you know how they're going to treat your client. And taking it to the box means that you get to pick people who are going to care for your client and are going to care for the law and are going to reach the right result. And taking it to the box means trusting your community, and also loving the civic responsibility that's involved. Nothing makes me happier than the part of a trial, that a lot of people find cheesy, which is where they do all of this in the presence of the flag of our country stuff. And it makes my eyes water. I've sat in more than one trial, and I'm sure watched jurors think, what's wrong with her? Because I'm just so happy to be there. And it's because that's what this country was founded on. And there's a lot of people that say a lot of things about what makes this country great, but this is absolutely it. And there's a reason that over half the Bill of Rights is dedicated to the jury trial. It's because it's the most important part of our society.
Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.